The grand marble pillars of the U.S. District Court loomed high above the bustling streets of Washington, D.C. Inside, the air was thick with anticipation. A high-profile case was about to unfold, one that had the media swarming outside and legal analysts whispering in hushed tones. The defendant? None other than Vice President J.D. Vance. The judge? Honorable Samuel C. Whitaker, a seasoned magistrate known for his unwavering stance on justice. The charge? Contempt of court. The alleged offense? Refusing to comply with a subpoena regarding a controversial executive order. As the courtroom doors swung open, J.D. Vance strode in, his face calm, his posture unshaken. Clad in his signature navy blue suit, he exuded confidence, not the arrogance of a man above the law, but the composure of someone who knew exactly what he was doing. Judge Whitaker, a man in his early 60s with a no-nonsense demeanor, adjusted his glasses and cleared his throat. Mr. Vice President, this court does not recognize special privileges. The law applies to all, no matter how high their office. Vance nodded respectfully. I wouldn't have it any other way, Your Honor. The courtroom murmured. The prosecution had built a case on Vance's refusal to turn over documents regarding a controversial presidential directive. His argument? Executive privilege. Their counterargument? No one, not even the vice president, is above a federal subpoena. The prosecutor, a sharp-witted attorney named Elena McBride, stepped forward. She was renowned for dismantling powerful figures with precision, and today, her sights were set on J.D. Vance. Mr. Vance, you were instructed to comply with a federal subpoena, McBride began. Yet, you deliberately withheld key documents that could impact national security policy. Is that correct? Vance folded his hands. I was advised that releasing those documents could compromise sensitive information. McBride smirked. That's a convenient excuse. But the court, not the executive branch, decides what's legally permissible. Judge Whitaker tapped his gavel. Mr. Vance, unless you provide a valid legal argument, I have no choice but to impose a fine for contempt of court. Vance's lips curled into a slight smile. With all due respect, Your Honor, before you issue any fines, I request permission to present my own legal argument. Whitaker's eyes narrowed. Are you planning to challenge the authority of this court? Not at all, Vance replied. I simply believe that due process allows me to defend my position. After all, if I'm to be fined for contempt, it should at least be determined whether contempt was actually committed. Judge Whitaker leaned back in his chair. The courtroom fell silent. Proceed, he said. At that moment, J.D. Vance transformed. No longer just the vice president, he was now the lawyer, the legal mind who had once been a Yale law graduate before stepping into politics. The crowd whispered as he pulled a small legal pad from his briefcase and flipped through his notes. The government is arguing that my refusal to submit documents violates a federal subpoena, Vance began. However, they failed to consider a key precedent, United States versus Nixon, 1974. In this landmark ruling, the Supreme Court acknowledged the doctrine of executive privilege but required that it be weighed against the needs of justice. McBride folded her arms. We're well aware of that ruling, Mr. Vance. Vance nodded. Good. Then you'll also recall that in that case, President Nixon was compelled to turn over tapes because the prosecution proved that justice outweighed privilege. But in this case, there has been no demonstration that the requested documents are indispensable for the prosecution's case. Therefore, no legal grounds exist for overriding executive privilege. Judge Whitaker raised an eyebrow. And you believe this court should take your word for it? Vance smiled. Not my word, Your Honor. The Constitution's. A murmur spread through the courtroom. Even McBride, usually unflappable, seemed momentarily caught off guard. Judge Whitaker tapped his gavel. This is getting interesting. The tension in the courtroom was palpable. J.D. Vance had just invoked United States versus Nixon as his primary defense, and now all eyes were on Judge Whitaker. The seasoned magistrate leaned forward, resting his elbows on the bench, studying the vice president with a keen gaze. Mr. Vance, the judge said, tapping his fingers on the desk, you argue that the prosecution has not sufficiently demonstrated the necessity of these documents. Yet, the prosecution contends that national security is at stake. Are you suggesting that this court dismiss such concerns? Vance shook his head. Not at all, Your Honor. I'm suggesting that before enforcing a subpoena against the executive branch, the burden of proof must be met. We can't assume necessity, we must establish it beyond question. Elena McBride, the sharp-eyed prosecutor, stepped forward, arms crossed. Very well, Mr. Vance. Let's put your argument to the test. She turned to the judge. Your Honor, may I present evidence that demonstrates the critical nature of these documents? Judge Whitaker nodded. Proceed. A large screen in the courtroom flickered to life, displaying a classified memo heavily redacted but revealing just enough to hint at a national security threat involving international negotiations. McBride gestured toward it. "This, Your Honor, is an intelligence briefing prepared for the Vice President," she said. "It details sensitive diplomatic communications regarding our foreign alliances. The withheld documents provide further insight into how the administration intends to handle these matters." J.D. Vance remained composed. "And yet, Ms. McBride, what you fail to mention is that this document is already redacted under national security protocols. Meaning, the very fact that it is classified at this level already establishes that full disclosure would compromise sensitive information." McBride scoffed. "And who decides that?" "You." Vance's smile was razor-sharp. "Not me. The Supreme Court, which has consistently upheld the principle that national security concerns may justify withholding certain information. In fact, let's reference Reynolds versus United States, 1953, in which the court ruled that the government may withhold evidence if its disclosure poses a reasonable danger to national security." McBride's jaw tightened. "So your entire defense is built on the idea that you alone can determine what's too sensitive for court review?" Vance shook his head. "Not me, Ms. McBride, precedent. Unless you're suggesting this court should override Supreme Court decisions." The courtroom buzzed. Even Judge Whitaker leaned back in his chair, rubbing his chin. "Mr. Vance," he said, his voice measured, "you're arguing that this case must first establish the absolute necessity of the documents before compelling their release. Yet you claim the very classification of these documents prevents such a determination. That sounds like a legal paradox, one that prevents judicial review entirely." Vance nodded. "It's not a paradox, Your Honor. It's the separation of powers. The moment the executive branch loses the ability to classify documents independently, the judiciary and legislative branches gain unchecked power over national security decisions. That's why courts have traditionally deferred to the executive's discretion in these matters." McBride clenched her jaw. "That's a dangerously broad interpretation of executive power." Vance shrugged. "Maybe, but it's not my interpretation, it's the legal doctrine of state secrets privilege. And as long as that precedent stands, my refusal to comply with this subpoena isn't contempt, it's adherence to the law." Judge Whitaker's fingers drummed against the bench. The entire courtroom waited for his response. Finally, he let out a slow breath. "I'll need a recess to review these arguments." With that, he banged his gavel. Court adjourned until further notice. As the spectators filed out, McBride shot Vance a glare. "You may have stalled this, but you're not off the hook yet." Vance gave a small smirk. "I never am, Ms. McBride. But that's what makes this fun." As the courtroom emptied, J.D. Vance stepped outside, where a swarm of reporters waited like vultures circling their prey. Microphones and cameras pushed forward as a journalist from the Washington Post shouted, "Mr. Vice President, do you believe you'll win this case?" Vance adjusted his tie, his usual confident smirk in place. "I believe in the law. The question is whether the law will be followed." Inside the courthouse, Judge Whitaker sat in his chambers, flipping through legal briefs and old Supreme Court rulings. His clerk, a young attorney named Daniel Hayes, knocked softly and entered with a stack of files. "Sir, I pulled everything I could find on Reynolds versus United States and United States versus Nixon. There's a problem." Judge Whitaker took off his glasses and sighed. "Of course there is. What is it?" Hayes placed the documents on the desk. "Vance is right, technically. The state secrets privilege has been upheld in multiple rulings. If we demand the documents and he refuses, he could take this to the Supreme Court and possibly win." Whitaker frowned. "So what you're saying is, if I fine the vice president for contempt, I might be the one violating legal precedent." Hayes hesitated. "There's precedent for both sides, sir. But one thing is clear, if you overstep, you could be setting a new precedent that shifts power away from the executive branch." The judge drummed his fingers on the desk. "Damn lawyers. Always turning the law into a chess game." Back in the courtroom. When the recess ended, the courtroom filled once again. This time, the energy was different. People whispered, wondering if the judge had reconsidered his position. Judge Whitaker took his seat and gave J.D. Vance a long, measured look. "Mr. Vance," he said, "this court finds that your refusal to comply with the subpoena constitutes technical contempt. However, based on legal precedent, I must also recognize the executive branch's privilege in matters of national security." McBride tensed. "Your Honor, are you saying he doesn't have to comply?" Whitaker continued, ignoring her frustration. "Therefore, I am issuing a symbolic fine, $1, to acknowledge the importance of upholding judicial authority while respecting the separation of powers. A stunned silence filled the room. A mere $1,000 fine? For a vice president, that was pocket change. McBride shot to her feet. Your Honor, this sets a dangerous precedent. Whitaker raised a hand. Enough, Ms. McBride. You made a compelling case, but the vice president has successfully argued within the confines of established law. J.D. Vance gave a slow nod, his expression unreadable. I respect the court's decision, Your Honor. The gavel came down. Court adjourned. As Vance turned to leave, McBride walked up beside him. You knew this would happen, didn't you? Vance chuckled. I had a strong feeling. Law is about playing the long game, Ms. McBride. You focus on winning a battle, I focus on winning the war. McBride sighed, shaking her head. You're insufferable. Vance grinned. That's what they said about Lincoln, too. News of the court's ruling spread like wildfire. Within hours, every major network, CNN, Fox News, MSNBC, was running headlines like, Judge fines J.D. Vance $1,000, but did he just redefine executive privilege? J.D. Vance's legal genius saves him again. A dangerous precedent? Critics slam the court's weak punishment. Inside the White House, President Matthew Holloway watched the coverage on a massive screen in the West Wing. His chief of staff, Laura Kendall, stood beside him, arms crossed. Well, Holloway muttered, he pulled it off. Kendall sighed. Barely. This could have gone either way, but now the public perception is split. Half of America thinks Vance is a genius, the other half thinks he just outmaneuvered the law. Holloway turned to his press secretary. We need a statement. Something that reinforces our commitment to transparency without throwing J.D. under the bus. The press secretary nodded. How about the vice president has always acted in the best interests of national security. While we respect the court's ruling, we remain committed to upholding the rule of law. Holloway grunted. Make it sound a little less scripted. The opposition's fury. Meanwhile, on Capitol Hill, Senator Marcus Green was fuming. A longtime critic of Vance and a potential presidential candidate, Green saw an opportunity to turn this legal victory into a political scandal. At a press conference, he stood at the podium, flanked by allies. Today we witnessed a travesty of justice, Green declared, his voice sharp. The Vice President of the United States was found in contempt of court and yet walked away with a fine so small it wouldn't cover his morning coffee bill. The crowd of reporters scribbled furiously as Green continued. What message does this send? That the powerful can defy the courts without consequences? That executive privilege is an excuse to hide critical information from the American people? If J.D. Vance had nothing to hide, why not comply with the subpoena? A reporter raised a hand. Senator Green, do you believe this justifies a congressional investigation? Green leaned forward. I don't just believe it, I demand it. Across town, J.D. Vance watched the broadcast from his office, sipping coffee as his chief counsel, David Ellis, smirked. Well, Ellis said, I guess it was only a matter of time before they turned this into a political circus. Vance chuckled. Let them. They'll waste months fighting a battle they can't win. Ellis raised an eyebrow. And what if they do win? Vance's smirk faded slightly. Then I'll remind them why I graduated from Yale Law at the top of my class. The uproar over J.D. Vance's court victory reached a boiling point. Senator Marcus Green's demand for a congressional investigation had gained traction, and the House Judiciary Committee was now set to hold hearings on whether Vance had abused executive privilege. Cable news ran 24/7 coverage, with legal experts, political analysts, and former government officials debating the implications. Fox News panel. Speaking head J.D. Vance played this perfectly. He outmaneuvered the prosecution and reinforced executive power. CNN roundtable. Speaking head, this isn't about legal genius. This is about dodging accountability. As hearings loomed, Vance met with President Holloway in the Oval Office. The air was thick with tension. Holloway leaned forward. J.D., this is becoming a distraction. The more they push this, the more it overshadows my administration's agenda. Vance nodded. I understand, Mr. President. That's why I have a solution. Holloway's eyes narrowed. I'm listening. Vance placed a confidential folder on the desk. This is a legal strategy that turns their investigation against them. Holloway opened it, scanning the pages. His eyebrows shot up. Are you serious? Vance smiled. Completely. The hearing that changed everything. The day of the congressional hearing arrived. The House Judiciary Committee chamber was packed, senators, reporters, and cameras were everywhere. J.D. Vance sat in the witness chair, calm and collected. Chairwoman Rebecca Hastings, an outspoken critic, wasted no time. Mr. Vice President, she began, this committee believes you have willfully obstructed the courts and withheld information from the American people. Do you deny this? Vance leaned into the microphone. I don't deny anything, Chairwoman Hastings. In fact, I'd like to submit something for the official record. He handed a document to the committee clerk who distributed copies to the panel. Hastings frowned. What is this? Vance smiled. It's a legal opinion from former Attorney General William Barr, written years ago, confirming that my interpretation of executive privilege aligns with existing precedent. Additionally, the Department of Justice's Office of Legal Counsel has supported similar positions multiple times. The room murmured as Hastings flipped through the document. Vance continued, so, before you accuse me of wrongdoing, perhaps this committee should consider whether you're challenging me or challenging decades of established legal doctrine. Hastings' face hardened. You're saying we have no authority here? Vance shrugged. I'm saying your own government has already backed my argument. Maybe it's not me who needs to be investigated, but the people trying to rewrite the rules for political gain. Silence. Then whispers. Then an explosion of media coverage. By the next morning, the congressional investigation was in shambles. Legal experts debated whether Hastings had overreached. Public opinion shifted. Was this hearing really about justice, or was it just a political witch hunt? Senator Green, seeing the tides turn, distanced himself from the attack on Vance. The White House press briefing emphasized unity, stating, Speaking head Vice President Vance has always upheld the law, and today's hearing reaffirms that commitment. J.D. Vance walked out of the Capitol that afternoon, greeted by a roaring press corps. A reporter yelled, Mr. Vice President, what's your takeaway from all this? Vance smirked. Simple. Never underestimate the law. As he walked toward his car, a knowing glint in his eye, America finally realized something. They hadn't just fined J.D. Vance. They had stepped into the ring with a legal genius and lost.